Most East Bay landlords don't think about eviction law until they're already in a dispute. That's exactly the wrong time to learn it. This month at All East Bay Properties, we're covering everything you need to know about legal notices, evictions, and owner protections before you ever need it. Here's what makes California eviction law complicated for East Bay landlords specifically. You're not dealing with one set of rules. You're dealing with three. California state law sets the floor. AB 1482 adds a statewide just cause requirement on top of that. And Oakland, Berkeley, and other cities also have local ordinances that go even further. When they overlap, the strictest rule wins. And in most Oakland and Berkeley situations, that means the local ordinance controls. If you own rental property in the East Bay and you're not sure which rules apply to your specific unit, that gap is worth closing before summer leasing season. So what does just cause actually mean? It means you cannot terminate a tenancy without a qualifying legal reason. Once a tenant has been in the unit for 12 months under AB 1482, or from day one in Oakland under the city's ordinance. Just cause grounds fall into two categories. At-fault grounds, like non-payment of rent or a lease violation, don't require you to pay relocation assistance. No-fault grounds, like an owner move-in or Ellis Act withdrawal, do. In Oakland, that's typically 1 month's rent. Ellis Act withdrawals require 3. Just cause doesn't make problem tenants unevictable. It means the eviction has to be based on a real reason, documented, and pursued the right way. The single most common and most costly mistake we see is landlords serving the wrong notice type for the situation. There are 3 core notices: a 3-day notice to pay or quit for non-payment, a 3-day notice to cure or quit for lease violations, and a 30 or 60-day notice for no-fault terminations. Here's what most landlords don't realize. The notice type is determined by the reason for the termination, not by how long the tenant has been there. Serve the wrong one and it's void. The tenant doesn't even have to show up in court. It gets dismissed on the face of it, and you lose 4 to 8 weeks restarting the process. One more detail that trips people up: if you accept even a partial rent payment after serving a 3-day notice to pay or quit, you've likely waived the notice entirely. So what should you actually do with this? 3 things. First, review your leases. If they haven't been updated since 2023 or earlier, they may not reflect current California law. Second, get your maintenance documentation in order, because an open repair request is the first thing a tenant's attorney will surface in a UD proceeding. Third, know which rules apply to your specific property before a situation forces you to find out. The full guide, notice types, the Alameda County unlawful detainer process, common mistakes, and owner protections, is linked below. At All East Bay Properties, we manage this process as a legal workflow, not a reaction to a crisis. If you're navigating a difficult tenancy right now, or you want a property manager who handles this so you don't have to, visit alleastbayproperties.com or hit the link below to schedule a free consultation.